Welcome, everyone. Thank you for joining us for our online conversation, Values-Based Estate Planning. Put your money where your heart is. I'm Kimberly Mueller, Development Manager at the San Diego Public Library Foundation, and I'll be your moderator today. There's been a lot of positive energy around this talk. People are responding favorably to the values concept. It's really resonating right now. First of all, for the benefit of all our attendees, we appreciate you keeping yourself on mute and with your camera turned off. Thank you. We will be recording this talk and we'll make it available to you. In our time together, we'll have thought-provoking conversations with our professional advisors. I'll be engaging them with some questions, and we'll discuss values and basic estate planning education that people need to make informed decisions. Then we'll take your questions from the chat box. So I encourage you to type your questions or comments for the experts in the chat. Please keep an eye on the chat, as we'll also be providing valuable links to websites. Among the highest searches on Google the last few months has been how to make a will. And let's face it, we're all thinking about our mortality right now. And what people are looking for is a trusted guide. The San Diego Public Library is a beloved, safe, trusted place that has lifelong impact. And the Library Foundation is a resource for our supporters and an early resource in their plan giving process. Over the past few months, I've been in touch with estate planners who've been seeing a dramatic increase in business due to the pandemic. People are wanting to create and update their estate plans to ensure that they reflect their current intent, to cover incapacity, and make it easy on their loved ones. And they want to make an impact. They want their lives to have made a difference. They want their estate plans to reflect their values. We've all been doing a lot of reflecting lately about what really matters. Living with meaning and intention matter. Our families matter. Our communities matter. We care about our favorite charities that are having such a profound impact when San Diego needs them the most. And before we begin, I'd love for you to hear from Patrick Stewart, CEO of the Library Foundation. Patrick?
Thank you, Kimberly. My name is Patrick Stewart, and I serve as the CEO of the San Diego Public Library Foundation. I want to say that we are so grateful for all the support from each of the organizations that we recognized at the start of this program. And on behalf of the Foundation's Board of Trustees, staff, and volunteers, welcome to this evening's webinar, and we're really glad to have you join us. The Library Foundation plays an important role in serving San Diego in that our mission is to strengthen our communities by supporting excellence in the San Diego Public Library system through philanthropy, advocacy, and outreach. The Library Foundation is a catalyst for creating stronger communities through investment in the San Diego Public Library system, where access to resources supporting literacy, workforce readiness, and lifelong learning ensure equal opportunities for success. Through building lasting relationships with our philanthropic and corporate community, through ensuring that our elected officials prioritize the value that the library has in every San Diego community, and in creating effective channels that convey that impact, the Library Foundation ensures that our library system has the tools and resources it needs to fulfill its vision every single day. But now, more than ever, we see that access to that vision may be especially prohibitive for many families in San Diego. As our library continues to provide innovative means of creating and delivering essential programs and resources, the Library Foundation, with the help of supporters just like you, has made access to these resources our highest priority. Providing computers to students participating in the Popular Library Next program, ensuring that participants in the library's Read San Diego and Career Online High School programs have the tools to continue their learning uninterrupted, and by bringing laptops to the courtyards and outdoor spaces of our neighborhood branches so that those individuals who rely on the library to stay connected to the world around us are able to do so are just a few examples of the Foundation's support for the work of our library system, support that wouldn't be possible without you. To that end, thank you. Thank you for your support of our library, and thank you for your interest today in how your support for the causes you value most can be provided for years to come. With that, I'll return to Kimberly so we can get started.
Thank you, Patrick. You know, I talk with Library Foundation donors every day, and when I ask them why they give, they talk about their values. Some value of theirs that's in alignment with the library's values. Maybe the library was critical to them as a child, or they believe strongly in free access to all, or education, or equity. Many professional advisors lead an estate planning discussion in terms of tax. And while that's important and will be covered, today's discussion is going to lead with values, getting to the heart of what your priorities are. It is my true pleasure to introduce you to our two presenters. Lisa Frisella is founder of Frisella Nielsen. She's an estate planning attorney who works closely with clients, trustees, beneficiaries, conservators, guardians, and heirs. Joe Forlenza is founder of Sky City Advisors. He uses his skills as a CPA financial advisor to help people connect their self-worth with their net worth. I know you two do excellent work for your clients, and we so appreciate your expertise here today. Joe, would you like to start us off?
Well, yes. Thank you, Kimberly. I appreciate that. And thank you, Patrick, for that wonderful introduction to the library and this talk on value-based estate planning. Today we're going to go through just a little bit about delving a little bit deeper into what our values are, how do we express ourselves through our resources. And I've established a company, Sky City Advisors. I'm a CPA and a CFP. I had a tax background, and then I decided to get into investment planning, which morphed into financial planning. And then I realized that financial planning really wasn't reaching my clients on a level that I had hoped to. I found that regardless of the amount of wealth that my clients had, I have clients and work with people that have very little to those that have very much. And pretty much none of them are happy. Maybe 5% of these people are considered generally happy with what they have. And I began to wonder why. And so I went in, and if Charlie, next slide, please. And I started thinking about it, and I developed this concept of plentyism. And plentyism is defined as, rather than hoarding wealth, plentyism is the ritual of consciously allowing one to begin to allocate their resources to what they value. And so what does that mean? That kind of speaks to a lot of what I was doing. And although I've always had a certain sense of self-care and taking care of myself and doing things that I wanted, I found I was doing things that were good for my pocket, but not good for my head and my heart and my well-being. And so with that, I developed this concept of plentyism. Next slide, please. So my path to plentyism, as I spoke briefly about, I started Sky City Advisors. I felt that I needed a new way to connect with and serve my clients. In other words, this traditional financial planning, investment management was not reaching what I had hoped to reach in the results of people's well-being and happiness with what they had. And so through that, I developed Sky City Advisors. It's an advisory firm. And then probably about 2.5 years ago, I was going through one of those little life events where you have a little issue and you have to spend a little bit of money. I had a little car incident and I had to lay out some money, and I was like, I'm always laying out money for bad things. So I decided to just consciously suck it up and spend some money on this thing called Spartan training. And my goal was to do one Spartan race. I hired a trainer with money that I didn't feel that I had. It was probably better off spent in my IRA, my 401k, invested. There's more prudent, practical things to do with this money. And instead I embarked on this Spartan journey, and I ended up completing what's called a trifecta. And I did these 3 big races. You can look them up. They're pretty difficult, but it was great. And my energy totally changed. It changed my life. It changed my happiness. And it also changed the amount of actual physical resources that I had come into my life, which I thought was interesting. And I attributed that to meeting people that were on the same wavelength as me, my own increased, I call it magnetism, I guess, or joy of life. And then the third thing is consciously creating connection, or what I call connective cords, with people who share my passions in life. So it helps to, these are people that when I say they catch my story, they're actually interested in the things that I'm talking about. And we develop a strong supportive connection network of support that is very important as we embark on these journeys, because they're not always accepted wisdom or practical things to do in life, right? Next slide, please, Charlie. So today I would like everyone, while we're on this call, we have this opportunity, about an hour's time. Let's use this time to explore our hearts. So like anything in life, there's going to be a practical or a mind side, and especially in the professions, law, accounting, engineering, there are many rules and regulations and things that you need to do to make these things, structures, viable. That's the head side. The other side is the heart side. And matters of the heart aren't always as clear. And I find that we have a tendency to rely on the head and ignore our heart side, or our intuitive side, or our self-support side. So I would always like to say that in planning, it's good to look ahead to the future, where we want to be. What does that look like? And then let's work backwards and figure out the structures that will support that future vision. And of course, in our estate planning, that's going to mean basically we're gone. We're looking down on our loved ones, on our world. And what does that look like? How have we influenced the world through our lives and our legacy? And that's really the gist of what we'll be working on. And this is what any good planner, advisor, attorney, CPA will work with these future outcomes and work backwards. So I ask you to take a couple minutes throughout this call, this Zoom, to think about what your outcome is. I want you to have a plan that excites you, an estate plan that excites you. It not only covers your obligations to your heirs, but you're very excited about what lives on after you. Next slide, please. So I like to create rituals, and a ritual is nothing more than creating a special space and time in your life to focus your intentions on something. It could be as simple as lighting a candle to set a tone for maybe a meditation or a nice dinner. It could be your morning coffee where you start your day, but it's a part where you carve out time and space in your life for the things that are truly meaningful for you. And find out ways that you can support and feed these ideas and activities, both now and in this case, when you're gone, and your legacy will reflect these values that you're identifying now and can communicate with people while you're here and have control over that. Next slide, please, Charlie. So what is a plentyism-based estate plan? How is this going to unfold for you? So you're going to think about your material wealth and the fact that will continue on after you're gone. And how is that going to affect the world, your family, your friends, your loved ones? And think also as well that the wealth that you have right now, that's going to probably, most likely, keep growing. And it could be a significant amount in 10, 20, 30 years. And how will those significant sums affect the world, your loved ones? And that's worth considering right now. You should have these thought-provoking conversations with your estate planning team. These would include your attorney, your CPA, financial advisor, insurance professionals. Now, these are all traditional estate tax professionals, but you may also have a coach or a friend or a trusted mentor that you would also want to tap on that. There are some very I guess, responsibility laden positions involved there and some heavy decisions that need to be made. So they're not things that should be taken lightly, and it takes a lot of consideration. And thirdly, what do you deeply value and how will you distribute that wealth accordingly? What will really excite you to see your wealth doing when you're no longer here? Next slide, please, Charlie. So assigning roles and resources. So when considering your trustees, executors, beneficiaries in your estate, you should consider the following aspects. So tell me about the dynamics of your beneficiaries. Number one, how do they shift under duress? Many people choose their children as their beneficiaries. You've seen your children from when they were children. You've known which ones had which tendencies. How do they respond when they're having troubles in life? What happens to them? Because death and illness are very stressful situations for people. And how will these beneficiaries respond to that illness or when you're passing? How do these people respond to power? Some people crave power. Maybe that was the child that wanted to be the hall monitor as opposed to the child that wanted to get into the lunchroom first online to get their lunch. Two different personalities there. How are you going to manage those dynamics through your estate plan? And then will your beneficiaries look back and ask, how much was I loved or not based on this distribution? And how can you explain these dynamics to your family while you're still here? Next slide, please, Charlie. So also the plentyism-based estate plan will include a self-awareness and connecting to your higher self. And that's key to staying centered and being aware of your family dynamics when you're gone. So your self-awareness is what makes you whole, what makes you centered. I think this is an area where a lot of us, we do what we should rather than what we need to do. We don't want to be seen as selfish. We don't want to be seen as, taking care of ourselves first. But the fact is, if you don't take care of yourself first, you can't take care of anybody else anyway. So, and it has a much better outcome if you do. Secondly, stress test your finances to develop an increased security and comfort that your plan will carry you through your life and beyond. And that would mean sitting down with a financial professional and seeing how much assets you have, what's your income situation, maybe your health, consider perhaps you're married, which spouse will pass first, and then figure out what these assets will do under reasonable circumstances and what sums of money you will be leaving behind, and consider how that would affect your beneficiaries. And then again, the connective cords. Develop these relationships with people who get you and support the vision that you want to create in your world now and in the future. And I would include that amongst your professionals. I think you have to have somebody that, number one, understands you and you feel comfortable, and most important, trust. And because if you don't trust people, you will not tell them what you want, oftentimes not even tell them what you have. And another part of the financial stress test is you also walk away with a list of all your assets that you can take to the estate tax attorney, and they will be able to have a clear picture of exactly what you're dealing with, and it'll save a lot of time and money on that leg of the journey. Next slide, please. So as we continue today, like I said, what do you want to create in this world? Thank you. And now I'd like to introduce or follow up with Kimberly's lovely introduction of my good friend, Lisa Frisella. I've worked with Lisa for many years now with clients, mutual cases, and I really know that Lisa takes these value-based issues at hand and really brings out these issues with her clients. So how are you, Lisa?
Hi, Joe. Thank you for that lovely introduction. I'm doing really well. I'm excited to be here and talk about this. At our firm, we've for a long time embraced these points that you've made, and we work hard to try to make sure that each client we work with has an opportunity to really think about what they want. We try not to rush the process. And in doing so, we take time just to make sure that each client gives that real thought to where they want things to go. And we have discussions that lead to hopefully an outcome. The trust itself, the distribution provisions that really reflect those values. So I'm excited to be here because I think this is an important topic. And I think just as Kimberly said, and Kimberly, thank you for the wonderful introduction as well, but I think just as she said, you know, we're all much more introspective at this point, and somehow, thankfully, as a result of this, it's okay to be thoughtful about what we want. Whereas before, I think we were moving so quickly, and that's good too, that we really didn't have time to slow down and think and consider a different way. So I'm happy to be here.
Well, thank you. So can you tell me some of the trends that you're seeing play out in your world right now, in your practice? I know that there's a lot of change going on. What are people coming to you and telling you that's on their minds?
You know, just as Kimberly said, you know, our own mortality is definitely is on everybody's mind. But I think something that has also shown through is a real sense of community. A lot of folks are feeling a sense of community, and for that reason, they really feel like it's important to be thoughtful about what they want to do with their estate. And this isn't, always we like I said, we talk and make sure that we understand what that individual's values are. But right now, people are really speaking from their heart. And just as Kimberly said too, we are very busy because it's top of mind. I mean, what happens? And I don't think most folks really think that something is going to happen to them immediately, but the issue of mortality has been brought front and center, and they're acting on it more quickly than they might have before. So our trend has really been to have a lot of clients who want to get in, want to get things wrapped up, want to get things done, and that's really important because planning can make life easy for their family. They're able to express their wishes and have things carried out the way that they want, rather than just the way that the state of California indicates.
Mm-hmm. Thank you. And obviously you do some state litigation, trusts and estates. What causes that?
Oftentimes, it can be a poorly drafted estate plan. And by the way, litigation has not slowed down at all. I initially thought that it would, because folks were thinking more so about their families, not wanting to take time and money to address litigation. But again, because I think folks are thinking more about their value system, they're actually acting more. They're filing more litigation because they're acting more so based on principle. So if they really do believe that something wrong has happened, they're initiating an action more quickly than they might have before. I know it seems counterintuitive, but that is what we're seeing. But I mean, in terms of why an estate plan can go sideways, why it can fail, most often it's a poor choice of trustee. I mean, most of our litigation is filed as the result of trying to get information from a trustee who is supposed to be doing a particular job, who is supposed to be serving as a fiduciary, but is not doing the job, is not communicating with the beneficiaries, is not distributing, usually their parents' estate as they have been directed to do in the trust. So I know we'll talk about this a little bit either now or later on, but choice of trustee is critical when you're creating a trust. And just as a point, trustee is the person who is charged with carrying out the administration of your estate once you've passed.
Yeah, can you go through and just give a little bit of a definition, trustee, executor, beneficiary, and fiduciary?
Of course, of course. So a trustee, you have multiple documents, and the trustee is going to be the individual who manages the trust assets. And trust assets are any assets that would be part of the trust. And I'll get into this a little bit more as we talk further, but that's where oftentimes the bulk of your wealth is. Now, you'll also have retirement accounts, annuities, potentially life insurance. So there are all kinds of different assets that you'll have. Some of those assets will go into your trust, and the distribution provisions within your trust will guide where those assets will go. So that is sort of it in a nutshell. An executor is the person who manages a will, and I'll get into that in just a little bit. But the agent is the person who will manage or act on behalf of the durable power of attorney. And fiduciary is just a word that sort of indicates what your role is, what your responsibilities are as trustee. So if I'm serving as a fiduciary, I have a higher responsibility to the person, usually a beneficiary, the person who's receiving in this case, to that person to make sure that I do a good job, that I account for my actions. And the best way to do so is to have the help of the team that you referenced, which is a good financial advisor, CPA, and estate planning attorney.
Well, thank you.
Mm-hmm.
And then estate planning process is difficult for people to start. I understand that. Why do you think people put it off, and how do you help them to come to terms with this task at hand?
Yeah, that's something you and I have talked about in the past, which is, why is it so difficult to go see an estate planning attorney? And I think oftentimes it's just that you haven't built a relationship with that person. You're expecting something, for lack of a better way of saying it, it's sort of cold and awful. You're talking about death. It doesn't generally give feelings of warmth and generally overall good feelings. And so for that reason, I think people shy away from it. They really don't want to deal with it. I think also, life is dynamic. And so as things change, you're thinking, well, maybe things will be different in the future. So maybe I'll put off getting this done until I really know what I want to do. And that's a good point too, because I think that's why so many people are acting right now, because they're kind of forced to really be introspective. And as a result, they are acting more quickly. But I do think it's just that they're nervous about the process. It doesn't sound like much fun, frankly. But if you can find a good estate planning attorney, develop a good relationship, that's key, because this is a person you're going to want to or need to meet with multiple times as things change. So the fear of setting it up initially shouldn't necessarily be present, because that over time you'll feel comfortable and happy going back to this person to make changes. And I tell folks that all the time when we're meeting. I say, look, if I'm not a good fit, don't continue on with this relationship, because I want you to feel comfortable in the future calling me, making changes, because that's key as life changes. It's why it's a revocable trust. You might want to make a change. So developing that relationship is key to actually carrying out having the wishes that you really value carried out over time, because you might change your mind.
Excellent, right? Yeah, I know I took my wills and trusts sat on my desk for a full year before I finally sent them back to the attorney. I didn't want to deal with the permanence of setting all that in stone, right? But knowing that it's changeable, it's a malleable document, it's a living document, really helps. Right. Real quick, what's the difference between revocable and irrevocable trusts?
Sure. So a revocable trust is one where you have the ability during your lifetime, so long as you have capacity, to change it or to revoke that trust. Most folks don't, once they've created a trust, it is revocable. The type of trust we're talking about today is just a revocable trust where you can make changes at any time. But an irrevocable trust is simply one where you just can't make changes to it once you've established it. And a lot of times there are good reasons for that, particularly as it relates to taxes and planning. But most folks create a revocable living trust.
Mm-hmm. And that is very malleable.
Yes.
Changeable. Well, good.
Right.
Well, thank you. That was great information, and really enjoying this conversation. I believe that Kimberly now has some questions and some comments for us as well.
Thank you, Joe and Lisa. Your conversation really does make one look within and think deeply. Well said. Now we're going to switch gears a bit and touch upon some simple estate planning options that can be in alignment with your values, maybe tax smart, and that support your favorite charity. These options are not complicated and there's an ease to them. And by the way, we've created a document called Simple Options for Making a Lasting Impact. There's a link for it in the chat. You can click on it right now, and we'll also send it to you by email. And a reminder to please type your questions and comments for our speakers into the chat box. So Lisa, perhaps you can get us started explaining some basic estate planning, what I call values-informed documents, wills, trusts, advanced healthcare directives, and powers of attorney. Will you please give us a brief overview of these documents?
Of course, of course. So, I think the first question most folks have is, what's the difference between a will and a trust? Simply put, a trust is set up to avoid your estate going through the probate court. Most folks understand that the probate court can administer your estate and will administer your estate if you have not set up a trust, but they usually don't want to go through this process because it can be lengthy and it can be expensive. But that's the process where the court oversees the administration after you pass, whereas a will, by the way, alone does not avoid probate. So even though you may create only a will, that will still goes through the probate court. And that's sometimes surprising to folks. But particularly individuals who have real property, even moderate wealth probably want to create a trust because that will be administered privately, usually by a family member, a fiduciary, a friend. It's the person you nominate as trustee is going to carry that out. In either case, the case of a will or a trust, your express wishes will indeed be carried out, but one with the trust, with the court, one without the court. And so in that document, in the will or the trust, you can express many things. You can express the percentages, the benefit, each beneficiary should receive. You can create what are called subtrusts. These are trusts that are set up to maybe delay distribution to a particular beneficiary or class of beneficiaries. You can even set up trusts that where the bulk of the wealth never really reaches that person. It's actually just held and administered by the trustee for certain items. It just depends on who's in your life, who you want to give to. And so those distribution provisions would be contained in your trust. Interestingly, even if you do create a trust, you will also have called a pour over will. And very simply, it's the type of a will that goes with the trust. And it just makes sure that if anything goes wrong with your trust, that your estate still has to go through probate, your estate will still be distributed in accordance with the distribution provisions you set forth in your trust. A power of attorney for finances is another document, and it just makes sure that the agent you've named, usually the same person you are going to ask to serve as your trustee, can manage any non-trust assets, and those are things like retirement accounts, potentially life insurance, annuities, particularly in the event that you're incapacitated. And to sort of prove that point, it doesn't really have any function after you pass away. So most folks will use a power of attorney when an particular individual doesn't any longer have the capacity to continue to manage his or her estate. An advanced healthcare directive is a document that's sort of two parts. Not only does it address end-of-life decisions because it's an advanced healthcare directive, so you're saying in advance what you would want to have if end-of-life decisions need to be made, but you're not in a position to be able to make them. Maybe you're, incapacitated. But keep in mind that person also makes decisions if you are sick for a long period of time, if you've been in an accident, you have dementia, Alzheimer's disease. I mean, you can live in that condition for 20 to 20 years, you know. So this is the person who decides literally who you see, what you eat, where you live, all of those very important decisions. And so to sort of bring that back to our value system, you really want to choose a person, in my mind, you really want to choose a person whose values are very similar to yours. Okay, so and trust me when I say, when it gets to end of life decisions, there are a lot, the devil's in the details, you know. Does this person understand that you want to avoid certain drugs until the very end? Or are you the type of person who says, look, if I'm even in a minimal amount of pain, I want, you know, all that the hospital that has to offer. I mean, these are really important decisions, and it's, if all other documents aside, this is really where your values come into play, because you want somebody to carry that out for you in the way that you would want to have it done yourself if you had the ability to do so.
Thank you. I know that was a quick review of these important documents. If you want to learn more, we are planning a future presentation where we'll go into more depth. So most of the Library Foundation's plan gifts are bequests. They're the most common type of plan gift. They can be a specific dollar amount, an asset, a percentage of the estate, and it can be simple to complete. Lisa, would you like to elaborate on bequests?
Sure. I mean, bequests are kind of, it's just a fancy word for making a testamentary gift. And there are lots of ways to do this. You can give certain assets by identifying them specifically. You know, some folks may have a fair amount of real property, and maybe they give the bulk of the real property to their children, but they have certain properties that they would also like to go to a charity. So that's a specific gift you could make. Obviously, most charitable organizations won't have too much use for real property. So, you know, the property is sold, whether it's a commercial building or it's a residential property, and that the proceeds are then distributed to the charity. Sometimes clients will bequeath shares of stock that they've held for a long period of time to a particular organization. And again, typically they're going to be liquidated and then the cash distributed to the organization. And these are specific gifts. And included in that are cash gifts. You know, I mean, certainly providing a certain dollar amount to a charity is a great idea. You have to keep in mind when you make that type of a gift, though, that cash gifts are made first. So if the value of your estate diminishes over time, if you've made a particularly large cash gift to certain organizations or even to your children, what's left after those gifts are made may not be the amount that you think it would be. And that's particularly true if you are sick for a prolonged period of time. If you have dementia or Alzheimer's, a lot of your wealth may go to your care. So it's an easy fix. I mean, in terms of making a distribution provision, you would just use percentages. You know, you'd say to this particular organization, I would like to leave 20%, and the remaining 80% goes in equal shares to each one of my children, that type of a thing. So, yep, that sums that up, I think.
And could you also talk to us about residuary gifts?
Sure. I mean, that is the residuary. So just what I was saying, it's just as it says, it's the residual of your estate after all taxes have been paid, gifts have been made, and certainly cash gifts in any amount can be made to support loved ones, and what remains could then go in the form of a charitable residuary gift. So it's just sort of the flip side. You'd give maybe cash gifts, large cash gifts to children, if that's what you wanted to do, or small cash gifts, it doesn't matter. And then the residuary is what's left over can go to a particular charitable organization or charity. So yes, that sort of describes what the residuary is.
Thanks. And as you two well know, getting the language right is so important. We always encourage our donors to notify us and advise us of their intent so we can honor their wishes. We do have sample wording that donors can give their attorneys, and that's in the simple options document as well in the chat. Another simple option, a donor can name a charity as a primary beneficiary of a portion or all of a retirement plan, IRA, a life insurance plan. It's so easy. You just type in the charity's name. So Lisa, could you talk to us more about beneficiary designations?
Sure, yeah. And so just as Kimberly said, retirement plans, annuities, life insurance policies, they're so easy. You know, there's a beneficiary designation form, and you have the opportunity to complete it in any way that you wish. And so these assets, by the way, are usually outside the scope of your trust. So you have trust assets, which could include your home, your bank accounts, your brokerage accounts, etc. It could be mineral rights. Any of those items can be in your trust. But generally speaking, you are going to distribute your retirement plans through the beneficiary designation form. And I think a lot of folks, when they're filling out that form, they get very nervous about it because they don't realize that you can divide that retirement plan in any way you want. It can be in, 10% to this person, another 10% to this organization. The forms usually are not incredibly user-friendly, so you should also rely on your estate planning attorney to assist you in completing them properly. So I think that they're just so straightforward, and it makes it easy to leave a portion of your estate to someone outside, even separate from your trust. Even today, I met with someone who said, look, I'm going to take this beneficiary out of my trust because I'm just going to leave my entire retirement plan to them. And that's an easy way to do it. It sounds like a lot of work, but we actually help clients have a spreadsheet so that they can see all of their assets, what's in trust, what's not in trust, and at the end of the day, see what's going to who and in what amounts.
The Library Foundation had a loyal donor who recently passed away, and who left us a portion of her IRA and kept it flexible. You never know what the libraries or the community's needs will be in the future. I mean, who would have thought we'd all be in the position we're in right now? We received the gift right as we had these new and growing needs that arose from the pandemic. And we were able to deploy the funds quickly because she left them flexible. We were in contact with her in her very last days. She knew this would happen, and it helped give her peace of mind. She said it was her honor, and that's impact. I'd also like to discuss charitable IRA rollovers. It's a current gift rather than a deferred gift, so that allows you to know your gift is being put to good use right away and see the difference your donation is making. My understanding is that a donor who's 70 and a half or older can make a qualified charitable distribution, QCD, commonly referred to as a charitable IRA rollover. It's a transfer of funds from their IRA to a charity, and they pay no income tax on the gift. Would either of you like to elaborate on this? Maybe Joe, you want to take this?
Sure. Yep. So in the last 4 years, there have basically been 3 major tax legislation bodies. The first one was the Tax Cuts and Jobs Act, which basically reduced tax rates and created like a preference for pass-through entities. On the gifting and the charitable space, there was a cap on the amount of money that you can gift to charity. It was capped at 50% of your adjusted gross income, basically your income. The TCJA basically stepped that up to 60%. This next one was the Secure Acts, setting every community up for a secure retirement. And that brought in the 72 and a half year when you start to take your RMD. Before that point, you had to take a required minimum distribution, which meant you had to start taking your money out at 70 and a half, even though you may not have needed it. because the IRS felt that you took a deduction and now they want some of their taxes back. So they pushed that out 2 years. And where a little bit of the confusion comes in now is then we have the CARES Act, the Corona Act, and they said, okay, well, you're still 72.5 for your distributions, but at 70.5, you can still take your RMD up to $100,000, and then you could give that directly to charity. And that is one way that the money benefits charity. It's also still one of the things that the original TCJA Act, it's the first act, did was eliminate most deductions, severely limited property tax, interest, and donations. So you would say, well, why not just take the income and then pass it through as a deduction? That's still allowable. Well, two reasons. And the number one is they've doubled the exemption amount to about $12,000. So a lot of people are not even itemizing. So this would be a way for people to give to charities and still take that $12,000 exemption. You won't have to eat into that. The other thing about this is it would not come into your AGI, so it would not affect your applicable credit reductions, exemption reductions. Maybe you're subject to AMT. And there's this dreaded 3.8 net investment tax. It's a surtax. Everything over a certain amount of income now is taxed at an additional 3.8%. So you can avoid that as well. So there are a lot of benefits to it still. It's a great way to give to charity and still do it in a maybe more tax efficient way.
And I understand that with a QCD, it's a great option for those who don't itemize their deductions or have maxed out their allowable deductions. Is that the case?
That's correct, yes. Yep.
You know, many donors find the IRA charitable rollover gift to be very easy. So, you know, all they have to do is call their IRA custodian and make the request. So it's very appealing to people. You've really touched upon this. I just want to see if you want to elaborate on it further. We've seen many legal changes in 2020 as a result of COVID-19, such as the CARES Act. Are there any specifics for this year that people should know about in connection with their planning and charitable giving?
Well, I mentioned that they have raised the cap to 100%, which may or may not affect people. The other one is they put a universal charitable credit in deduction for $300,000, or not $300,000, $300, and which is almost irrelevant. Most people, they would probably give 1 or 2% of their income normally anyway. So it did not do any, it wasn't an impetus for anyone to increase their giving. But they did give this $300 charitable deduction, a universal deduction. So not a whole lot has changed. They, in hindsight, with the CARES Act coming out and it being such a hard hit, especially to a charitable nonprofit foundation world, I think they should have put a little bit more thought into it and put together more of an effective credit system or deduction system, but they did not. But that was the basic broad outlines of it all.
You know, we always recommend that people consult their qualified professionals for their financial, tax, estate planning. Do you two have any suggestions for people who are looking for this type of help?
Sure, I'm happy to, oh, go ahead, Joe. You go,
Oh, you
go
got
ahead.
it. Go ahead.
No, I'll follow up. Go
Oh,
ahead.
I was just going to say, if you have a trusted professional already that you work with, if you like your tax attorney, if you like your CPA, if you like your financial advisor, they know other people playing in that space. And chances are they have similar personalities. And they also know their clients' personalities, and they would have select stable professionals that they would refer that would be compatible to their clients. So I think your current professional relationships are a good place to start.
And I would echo that. I would just say that, you know, just sort of what we had talked about before, which is that if there is a particular person in that group that you're not absolutely thrilled with, look around and don't hesitate to find someone who really meets your needs. And Joe's totally right. You know, when you do find that person, they're generally going to know similar people. You know, it's really not just looking for someone who knows how things work. I mean, that's, you know, Joe just gave you some great information, some technical information, but you really want someone who is going to move beyond that and also have sort of the less technical aspects in mind, and can help you with just what we're talking about, which is values based estate planning, values based financial advising, you know, that type of thing.
Yeah, this discussion has been so good because it's, you know, I want to talk with someone who is really looking deeply into what my dreams are or what excites me, what matters to me, rather than it just being transactional.
Exactly. And I think, you know, this is a conversation we've had even offline here, and I think it's nice to have it with each other and involve other folks in the discussion, which is, you know, sort of goes back to Joe's concept of plentyism. And that is, you know, even when you're making, you know, deciding what your distribution provisions are going to look like, most folks really just think, okay, I've worked this hard, I want my children to have everything that I have. And that's wonderful. I mean, that makes good sense. But because of what we've been going through with COVID, I think that we do recognize the importance of the community around us and those other individuals and how our community actually impacts our children as well. And so I think we, from sort of a selfish standpoint, we're doing our children a huge favor by investing in the community, because that impacts them too. It's not just direct impact, but it's indirect impact. And I know we've also talked about, you know, what that says to your children. You know, it sort of explains to them that I care about our community and I hope you will too. And these happen to be the certain charities that really excite me, and you should be involved in those that excite you as well, because that really makes for a nice community. It makes for a nice place to live. It makes for good neighbors. And so, you know, I think that's why knowing the tax laws is obviously very important. Knowing how to put together proper distribution provisions from a technical standpoint, obviously very important. But then really carrying out what you want and what excites you, just like you said, Kimberly. I mean, I think that's what really gives everyone a real sense of community, and is what leaves a true legacy. And I also think that, you know, you've touched upon the idea that it doesn't have to be a lot. You know, it really just has to say something. If you have modest means, that doesn't mean you can't give to something that really, some organization that really matters to you. So that shouldn't be something that you worry about as well.
Yeah, I get that a lot from donors. They're wondering if they need to be of great wealth to make a planned gift. And, you know, I say, no, not at all. Most of our planned gifts come from people of moderate means. Mm-hmm. And they can make a planned gift, they can make a huge impact. And as we're saying, it has more to do with that, with a deep belief in, with a connection to the mission.
Right. And you'd asked earlier about, you know, how our clients doing things a little bit differently, if at all. And I think a lot of clients are absolutely guided by obligation as it relates to how they give. You know, do I feel obligated to give to my children or my sister or someone in my family who maybe hasn't done all that well financially? And it's a struggle between obligation and what excites me, you know? So I think what a good professional does is helps a client decide, okay, how much do I need to give sort of out of obligation to make that sense of me feel good versus what really excites me and where I really want this money to go and where I really want to make an impact. I have lots of clients who really care a lot about children and education, and so they'll give in that department. And then some folks just love animals, and I mean they just want to make sure that particularly now animals and pets are being cared for, and that those charities continue to thrive and provide, just like you said, in this sort of COVID environment.
And I would just like to add a point, and it kind of relates to a question in the chat. Do you have any advice for strategies encouraging a parent to reconsider their estate plans without seeming insensitive, and getting to, how you want your assets to flow? That's one thing. Recognizing them and carrying it out, that's another big step. And then the third one, which I see most people do not do, is actually involve the children in the estate plan. So many of my clients come in, my parents have passed, I haven't even read the will, we're just going through it now, and it's a fiasco. And if they find out that, maybe money went to a charity, they may take it negatively often. And so if you can sit with your family, explain to them why you're doing these things, you can rebalance it, maybe have certain restrictions that you feel need to be put in place. Maybe a parent is an addict and you want the money to go to the grandchildren and then to disperse it back up to the parent. How do you handle that? Very sensitive issues. So I would recommend people to involve the family and not just like release it upon them on death. And that's, I would be very helpful. And it will make the whole process a lot easier.
Joe, you're so right that it's so difficult when a family comes in and has not seen the trust and has no idea what's going to happen. Kimberly, you'd asked earlier, what causes litigation? That does, a surprise like that leaves that person not able to comprehend why something happened, and now they want to ask they're usually their parent, why did you do that? And they don't have the opportunity to because they're no longer here. I mean, just a simple answer oftentimes would make such a difference. And I think people are afraid, if you're not leaving a lot to your children, you may not want to let them know because you feel like, maybe they won't, I don't know, maybe they won't like you as much, I mean, again, values-based planning says, well, then that's not really valuable to the parent because the relationship really maybe isn't built on love or other sort of emotions that would make more sense in that situation. So I totally agree with you. It would be so nice if folks would just talk about this in advance. If they're going to be hurt feelings, maybe let them happen so that they can be worked through before we get to the point of a person passing. Let them get used to an idea. Give them some credit that they'll be able to handle, maybe what you're thinking. And maybe even after a conversation with that child or family member, you change your mind, because you have a different understanding of how they feel. So I agree with you. Communication is absolutely key.
Yeah, that was a good point. If you have the difficult conversation now while everyone's alive, it allows the relationship to grow. And you don't know what those results will be.
Right.
And you may get positively surprised. So that was a great point.
I have this isn't really a question, it's just something that I have learned, is that over half of donors establish their first charitable estate gift when they make their first will or trust. And I was just wondering if either one of you wanted to comment on that.
So you mean initially when their distribution is, I think folks are oftentimes either charitably inclined or they're not. So when they do, embark on creating an estate plan, if it's important to them, then that's going to be the first thing they do, is just to make sure. I mean, a lot of folks say, we give during life. And so we want to see the benefit of what we are giving during life. And boy, there's no harm in that. Charitable organizations absolutely love to have relationships with their donors. And so, that should sort of encourage you to create that relationship. Don't wait until you pass to leave something to an organization, leave an asset to an organization or a gift, because you don't get the benefit of really enjoying that community with that organization, and it doesn't allow the organization to be able to thank you during life. So I think that's another important point as well.
I'm really enjoying our conversation. I think it's time, though, to turn to our attendees' questions. Natalie Gans has been monitoring the chat. Natalie is the Library Foundation's Chief Strategy and Engagement Officer. She has over 10 years of plan giving expertise. We have a strong team and are a trusted resource for plan giving. Natalie, would you like to join us?
Yes, thank you. And thank you, Joe and Lisa. I've been enjoying this so much. It's caused me to think about so many important things. And we've had some questions come up. Some of them we've kind of touched on already. So I'm going to do my best to link related questions to try to keep things thematic. And if I think we've covered it, I'll let you know on that too. So the first one, which is actually very interesting, is this person, not me, but this person says, I am under 40 without, quote, wealth. I am not under 40. And they say, why should I be thinking about estate planning? A young person who doesn't perceive themselves to be wealthy.
I think the important part there is that you know, whatever age you are, you probably have feelings about where you want your wealth to go. I mean, if you don't do anything, then, not to be too technical, but your estate would just go by the laws of intestate succession, and that's just, where does the state, you know, leave your assets if you haven't been clear yourself. But I mean, I think anybody with a value system would want to know where they were leaving even the smallest of assets and wealth. So, you know, for that reason, I think it's important. It reflects on who you are. It tells folks who you are, whether you're living or you're not. So for that reason, I think it's important to at least prepare a will if the assets are really not, doesn't make sense to do a trust.
Yeah. And I mean, I remember I was in that same situation when I made my estate plan, and what motivated me is I was working at the time for a healthcare organization, and hearing about nurses who didn't know what to do because someone didn't have a healthcare directive. And I knew at the time, as a single person, that healthcare directive was so important, even regardless of the dispositive provisions. Yeah.
Right. I mean, great point too, because in speaking, when you're talking about estate planning, you're not just talking about your wealth, but your advanced healthcare directive, your well-being. I mean, I won't go too far into conservatorships, but they're sort of the alternative when you haven't created an advanced healthcare directive yourself, when you haven't appointed somebody who can make decisions for you. You know, if you're, knock on wood, if you're in a car accident and you're unconscious for a long period of time, or even a short period of time, somebody has to make those decisions, you know, and they're not going to just take anybody's word for it. And it's not up to the hospital, the physician working on you, the nurses working on you, kind of decide, well, I think you'd make a good person to act as there as your agent. I mean, that's your job to say, this is the person I want to act, and nobody's going to rely on anybody but you to make that decision.
Yeah, another aspect that people would want to think about is their children and pets. You may not have a huge taxable estate, but you and your spouse, or maybe you're single, you pass away, you have minor children, you have pets. What's the direction given there? And that's something also to think about.
Hugely important. Yeah. Yeah. Very good. Switching directions a little bit, one of our participants has asked, will the home be reassessed if they put it into a trust?
No, it will not. Nope, that is not a reassessed, there's no reassessed value for putting it into a trust, very simply put. Because really, if you think about it, you're just transferring it, you're not transferring it to a new entity. A trust is not considered a business entity of any sort, so it's not a true transfer like the county recorder defines it. So it's just a transfer from you to you, from you as an individual to you as trustee of your trust. So the short answer to that question is no.
Great. Another great question here. If I move out of state, do I have to recreate an estate plan in the new state I live in?
And that's a great question too. Powers of attorney and trusts are all based on state law. There's no sort of federal trust or estate planning law. So yeah, they can be different in different states, but usually what I suggest to clients is bring what you have. If you've created a trust in California, bring that to your new estate planning attorney in New Mexico. And that person may say, it looks good. I don't think there's anything you need to change immediately. If you still own real property in California, let's leave it as is. Sometimes, certainly your advanced healthcare directive created in California should work in any other state because it's a pretty basic document. It's just saying who you're appointing and what you want to happen. And so it's just a matter of someone reading that and understanding it. So it depends on your comfort level too. Do you want to know that this is absolutely established under your new state's laws, or are you comfortable kind of waiting and seeing and then making changes as time goes on? But the answer is it just depends.
Sure. And even if you haven't changed where you're living, if you're still here in California, some people get worried that making changes to the plan might be a cumbersome process. And often it's just a page or so, an addendum for a trust. Right. So if somebody, sometimes people say, how often do I need to review my trust, see if changes are necessary? And you can tell me, Lisa, this is what I've told people. You can tell me if I've steered them in the right direction. I've always said, think about whatever holiday has happened at about the time you made your trust. And then every year around that time of that holiday, so maybe it's Labor Day or Halloween, whichever one you affiliate with at this time of year, dust off the trust and take a look at it.
I think that's great advice because really what it comes down to is, hopefully your estate planning attorney has given you enough information. I always tell my clients, look, I'm going to try to explain this thoroughly enough that when you need to make a change. Because you may say, And remembering who you named as the trustee, I can tell you most people within a year who they named, they're like, oh gosh, I better go look at that. So looking at it is extremely valuable. Just once a year, once every 6 months, whatever the case may be. If you forget who you've named, then you should look and see. But also understanding the trust is extremely important. And so the more you understand, you'll know it well enough to say, oh, I need to go make a change now. I need to update my schedule of assets. I need to title this new asset in the name of my trust. You'll have the ability to do so. Again, the true value in a good estate planning attorney is advising their clients well enough that that client knows what to do.
Yeah. And you talked earlier about communicating your plans with your family and the beneficiaries. I know from the charity standpoint, we always want to make sure we implement that person's intent. And if we have questions, if there's anything that's unclear, we always want the opportunity to clarify and make sure we really understand that, because that's so important to us. And we've been asked, are there practical strategies for sharing your plan and healthcare directive so everyone is aware and knows? And in this person's situation, it's with multiple children involved.
Joe, you want to field that one? Yeah.
Yeah, sure. So I recommend everyone have a copy of their will and trust at home, make their family aware of where it is. Put one off-site in case your house burns down, maybe your office or a bank safe deposit box. and also, of course, at your attorney. And make sure that your family has your attorney's phone number and name, and they will suss it out. But have multiple copies and disperse them geographically in case of some sort of a disaster.
Yeah. And you just, for some reason, something you said there, Joe, just prompted me to think about, if I've named someone as my trustee, of course, they should get those copies. But what happens if in the interim something happens to them and they predecease me, or they are unable to serve? What happens in that case?
Lisa.
Yeah, but I mean, generally you're going to name more than one individual as your trustee. So usually I'll ask clients to give me at least 2 or 3 individuals that they think would do a good job serving as trustee. A lot of times the question comes up, well, what if this person lives on the other side of the country? And I say, you know, look, if this person is truly the best person for the job, pick them, identify them, and if they determine not to serve because it's too difficult, then they can resign or pass on the position, and it goes on to the next person. But definitely choose the person who you think would do the best job. And you know, one of the things you had talked about was that the trustee oftentimes thinks they're in a position of power. I mean, and to be honest, they're in the exact opposite position. They're in a position of service to the beneficiaries. You know, it's a tough task to serve as trustee. You know, you've got sort of fire from everyone asking what's happening. Why aren't you moving quickly enough? Why didn't you list mom's house for sale at a higher price? Did you get an appraisal first? I mean, you've got a million questions coming at you. And so as a parent, you also have to remember that you are subjecting your child to this kind of scrutiny. And it can be legal scrutiny as well. You know, like I said before, if a beneficiary is really unhappy and has maybe good reason to be unhappy with how a trustee is doing, they can bring an action to have that person removed to account for what they've done. And it might, you know, keep in mind that you also want that trustee to be resourceful, you know, that you want that person to know that they need to see an attorney, first of all, to help them through this process, because if they make a misstep, they can be in a lot of hot water really quickly and without even realizing it. So with the assistance of an attorney, administering the trust, you've automatically, usually most attorneys will automatically send out communication to the beneficiaries, and that communication is key, and it explains what's happening, and it puts the beneficiaries' minds at ease that things are going to be carried out the way they were intended and in accordance with the laws of the state of California that govern that. So
yeah, I mean, from the charity side, when we are administering these gifts, we're always so grateful for the help of that trustee and the professionals involved, the attorneys. And it's, you know, we definitely recognize that is their service. It may be considered somewhat of a privilege or an honor to be listed as somebody's trustee, but it's also a job. It's a big responsibility, and we're always so grateful for what people contribute to that. Okay, so we talked a little earlier about the difference between designating a percentage of your assets versus a specific dollar amount. Are there any pros or cons to that choice?
From like a tax standpoint, or just from the standpoint of a
well, this person questioning didn't specify, but
okay.
Yeah.
Okay. I mean, no, there's not necessarily a real benefit except the one that I mentioned, which is that, you know, say you have a $500,000 estate, and you've made a $100,000 gift to a particular individual or charity, a cash gift, and then the residuary, like we talked about, is to go to 5 other beneficiaries in equal shares. Okay. If say, you know, at the end of your life, you need an extraordinary amount of care, it's extremely expensive, And when you pass, your estate is only worth, not only, but is down to maybe 250,000. That 100,000 cash gift is going to go out first. So you've given essentially 50% of your estate when what you really intended was to give 20%. So like I said, that's easily remedied with percentages. You know, you would just say, I'm going to leave 10% or 15 or 20% to a particular individual, and then the rest to those other beneficiaries.
Yeah, much easier to make sure you're treating your beneficiaries equally, if that's your intent. Otherwise, you may say the house to one person and the brokerage account to somebody else, and changes in value happen in ways that you didn't expect.
That's right.
Yeah, so let's see. Okay, so this person has an asset that they want to place in their trust and wants to know how you do it. Is it through a quitclaim? And they used to, because I used to get the form from the office and filed. So is there a form for that? How does that happen? And it could be an asset you acquired after the trust was created.
Right,
what do you
right.
do?
I mean, you really want to think of your trust as a receptacle into which things can go, and it changes over time. You know, you're going to sell an asset, you're going to purchase another asset, maybe, and so, you know, one thing we didn't touch upon that is really critically important when you create a trust is something called funding the trust. And that just means you're actually making the connection between that asset and the trust. So that the trust has the legal ability to govern what happens to that asset. So if I create a trust, but my house is in my name as a single woman, or my name as a married woman as community property, the trust technically at that moment does not have the ability to govern what happens with that house. You know, and the same applies to a bank account. You know, you want the bank account to be titled in the name of the trust. That way, when the trustee walks into the bank and says, I'm here to marshal this asset so that I can distribute it to the beneficiaries, you don't get a response from the teller that, I'm sorry, this isn't actually titled in the name of the trust, so you're kind of out of luck. I mean, there are ways to alleviate that, and we certainly have built-in backup plans so that we can address that. But oftentimes, if you buy a house, you created your trust, you buy a house 5 years later, and you don't title it in the name of the trust, and you don't add it to your schedule of assets, the court, nobody has any evidence that you intended for the trust to govern what happens to that. And so we have to go through a lengthier process to get everything managed. That's usually where your pour over will comes into play. So like I said, there's always a backup plan, but you'd rather go with plan A, right?
Right. I mean, like you said before, administering the trust is difficult enough.
Right.
Why make it more complicated? And this is a very nuts and boltsy question. How much does it cost approximately to create a trust?
I'd be disappointed if nobody had asked that question, of course, because that's usually question number one. I mean, every attorney is different, but I can tell you it ranges from anywhere between, you know, I'd say for a single person, $1,200 to $1,700, maybe for a married couple, anywhere from, you know, $1,900 to $3,000. I mean, I know it sounds like a big range, but it just depends. You know, again, if you meet with an attorney and you get a questionnaire and you're literally signing the next meeting, you know, you've submitted a questionnaire, you go in and the attorney is ready to sign, it's very likely that's not what you want to do. And likely you're paying a lower price for that. But you're definitely not getting that values-based estate planning that we're talking about, where you can really talk with that person. We meet with our clients usually 4 times. And in estate planning, that's a lot. But we've never been able to kind of do it any other way and feel like we've developed a relationship and truly understand what our client wants. So,
yeah, there's that, as well as the flexibility of the actual document. Just because it's a boilerplate trust that, you know, it's got the basic components of a trust. Well, can you change the trustee? Can you swap assets? Can you you know, there are so many different aspects of the language that allows you to do things and your trustee to do things when you're gone. That is a lot of value that people underappreciate. And that's kind of what you're paying for with law, right? So I have a plumber come by, right? And he comes in, the thing doesn't work, he goes under, he taps the pipe 3 times, and all of a sudden, whoosh, the water goes down the drain. He gives me a bill for $100. I said, you just tapped it 3 times. I knew where to tap.
Yeah, that's right.
Knowledge, right? That's what you want. You want, you know, anybody could go online and get an online document, but when you die, it's probably not going to do what you thought it was going to do. And even when you're alive, it may have problems with it.
Right.
So none of this revocable type trust should give you too much of a problem while you're alive. But
Right.
And I agree with you. And I mean, it's a risk you just don't want to take, you know, that it's going to, you won't know that it went wrong ever, I guess, you know, but I don't know that that's a risk that you want to take.
Your family will know it went wrong.
They sure will.
And so it's, you know, one of those situations where you have to think about if you're cutting corners on cost, it might not be worth it. You know, you have to, I always think of it as like dental care and things like that. I don't want to cut corners on that, right? Those are important things.
I want to be aware of time, Natalie. So maybe one last question.
Okay. Perfect, because we have one more and that's it. And that's, how long does it take to create a trust?
In many ways, it takes as long as you want it to take. So, you know, I do definitely have sort of emergency situations where maybe somebody's going in for a surgery and it's riskier than they thought. And they say, look, can we get this done as quickly as possible? You know, even within a few days. And the answer is, of course, yes. You know, we're just going to spend more hours in a day working on it and getting it done. And then I have clients who, you know, they like the process of kind of waiting and thinking about it, seeing their draft and looking it over and making edits to it and deciding maybe I would rather do this. You know, they sort of enjoy the process. So there's not a perfect answer, but if I had to say on average, how long does it take? Most folks take about 3 weeks to a month to get it all done.
Not so onerous when you think about all that you're accomplishing with that process.
Right.
You know, and like you said before, this is a living document. So you might say, yes, my trust is complete, but it's not finalized until you've either made it irrevocable or your life has passed.
Right.
Okay, so I don't see any other questions in the chat. So thank you to our speakers for being so receptive and helpful to our guests. I'm going to pop off now. Thank you, Kimberly, for guiding us through this presentation. And thank you to everybody who's joined us.
thank you, Natalie.
Yeah, thank you very much for inviting me to talk about this.
Thanks, Natalie. And thank you to our attendees for all your meaningful questions. If you didn't get your question answered, please feel free to contact Joe, Lisa, or me. Our contact information is in the chat. It'll be up on the screen shortly. There it is. And we'll email you the links as well. So Lisa, would you like to share some closing comments?
Sure. You know, I love the idea of this of values-based planning. You know, it's something that I feel like we've done it for a very long time and really didn't sort of know that we were doing it, which is a little, you know, odd, but we never really put a name to it. So I really appreciate the fact that Joe is focusing time on this and coming up with the idea of plentyism and what it means, and just making sure that folks are thinking about this very important part of life. And thank you very much. Thank you for having me. I appreciate it.
Joe, share some comments.
Yes, well, first I want to thank everybody at the Library Foundation. The whole team has been wonderful in putting this together. Thank you for all of our attendees and participants. There was great questions. I really enjoyed this. And yeah, so I'm not even going to say the pandemic. It's just been 2020 all about has been time to really rock our values and what we believe in. I think people have radically reevaluated their values and their commitment to their traditional roles and their way of life, right? A lot of people, they want something different now and they know it. And so plentyism, the reason why I came up with plentyism is because I believe people are happy when their hearts have plenty. So if you explore your heart and you find things that make you happy, you should pursue them and you should make the hard choice of actually committing your resources to that. A lot of people don't do that, and I think you will find a big shift in the way you view life and your money. So I really appreciate this time together, and I look forward to any questions you may have. Please email myself, Lisa, or Kimberly. Thank you very much.
I want to thank our wonderful speakers, Lisa Frisella and Joe Forlenza. We deeply appreciate how generous you've been with your time and expertise. And to our attendees, I'm so grateful to you. My wish is that you have found value in this conversation today. Please do visit the Library Foundation's Planned Giving webpage and read the stories of donors who are using their estates to carry out their values. We have those links in the chat. If any of you have made a planned gift to the Library Foundation, thank you from my heart. We invite you to join our Carnegie Society so we can thank and honor you, and you can be part of this community of supporters. Please be on the lookout in our e-newsletters for future estate planning webinars and other talks throughout the year. If you'd like more information on planned giving, please contact me as well as your professional advisors. I hope this conversation has been beneficial to you. It's certainly been enjoyable for us. I hope our paths cross again soon in person at the library. Thank you for joining us.